it would be unfair to make a ruling before we have had the benefit of legal representation in that matter.
He's run for president 4 times. He's been arrested more times than most people have changed jobs. And right now, he is sitting in a Ugandan prison cell, facing charge that carries the death penalty. His name is Dr. Kizza Besigye, and the case against him isn't just a legal story. It's a window into how power holds into itself. Over the next 15 minutes, we are going to walk through exactly what he's accused of, how he ended up in a Ugandan courtroom after being taken from a neighboring country, and why lawyers, judges, and international observers can't agree on whether this is justice or a theater.
How do you want me to plead when you have cut out the possibility of having the highly needed advice of my lawyers as granted by the Constitution of the Republic of Uganda and by law?
I would allow you to say something, but let me know your position on this. If you are not pleading, so tell me that you are not pleading.
I'm not in a position to plead without advice.
It's okay.
Simply not possible.
I
don't know how many times I've been chatting with the prison.
I am saying
prison that never becomes.
Doctor,
So
I'm
fed up of this persecution.
I am using section 63 and I have saying free of not guilty under section 63.
To understand this case, you need to understand the man and his decades-long relationship with one other man, Yoweri Museveni. Besigye was once Museveni's personal physician. He fought alongside him in the Bush War that brought Museveni to power in 1986. For years, he was an insider in the same movement he would later spend his life opposing. That changed in the late 1990s. Dr. Besigye became one of the most prominent critics of Museveni's increasing long grip on power. He ran against him on president in 2001 and lost. Then again 2006, 2011 and 2016 and lost each time, in elections that international observers repeatedly flagged as made by irregularities. Along the way, he was arrested, tear-gassed, beaten, and at one point flown out of the country mid-protest by his own government. To his supporters, he is the closest thing Uganda has to a symbol of democratic resistance. To his critics, includes the government, he is a serial agitator who has spent 30 years trying to seize power he could never win at a ballot box. By late 2024, Besigye had stepped back from frontline party politics. Then in November of that year, he disappeared. Here's where the story gets murky and where the facts are genuinely disputed. Besigye traveled to Nairobi, Kenya in November 2024, and according to his family and legal team, he was seized there, not arrested through any formal extradition process, but effectively taken by force and transported back to Uganda. Kenyan officials have denied any official complicities in his detention. Ugandan authorities have taken a different position, saying their Kenyan counterparts were fully briefed through routine intelligence cooperation between the two countries. Neither government have offered a fully transparent public accounting of exactly what happened in those days. What we do know is that Besigye resurfaced in Uganda facing not ordinary political charges but treason, and at first in a military court. That detail matters enormously, and it's the subject of part 3.
That this is a dangerous precedent that we are picking up. As a nation and as a country, we should not be seen as the haven to break laws, the haven that any person who may be within our jurisdiction, we have opened a wide berth for them to be picked up, for them to be subjected to any inhuman treatment or torture in any way.
As a commission, working in liaison with other human rights institutions, especially our sister commission in Uganda. We will get in touch so that we see how we can ensure our region is compliant in terms of human rights.
Initially, Besigye and his co-accused, his aide Haj Obed Rutale Kamulegeya and the Uganda military officer Captain Dennis Ola were slated to be tried before a military tribunal, even though Besigye and Rutale are civilians. Trying civilians in military court has long been one of the most criticized features of Uganda's justice system. Rights groups have urged for years that military courts offer fewer due process protections, operate faster, and are more susceptible to government influence than the ordinary judiciary. In protest of his treatment and the venue of his trial, Besigye launched a hunger strike, refusing food for weeks. Then, in January 2026, Uganda's Supreme Court ruled that trying civilians in military court was unconstitutional. It was a landmark decision, and it forced the case out of the military system and into a civilian one. The High Court's Criminal Division in Kampala, Besigye ended his hunger strike shortly after. It looked briefly like a genuine legal collection. What followed was a slower, messier fight over something that sounds procedural but is actually the whole ballgame disclosure.
And misprision of treason.
The court has been avoiding the application in the Human Rights Division, which touches, among others, on the Chief of Defense Forces of Uganda, has been fixed, yet the bail application, which was filed 2 months ago, has not been fixed. The court has just said.
Let's be precise about what the prosecution is actually alleging, because treason can mean a lot of things. According to the charge sheet, prosecutors say that Besigye, Rutale, Captain Ola, and others still at large held meetings in Uganda, but also in Kenya, Greece, and Switzerland between roughly 2023 and 2024 as part of an effort to overthrow the Ugandan government by force of arms. Rutale is separately accused of misprision of treason, meaning he allegedly knew of a plan to commit treason and failed to report it to the authorities. All three men have pleaded not guilty. Their defense team says the case is thin, procedurally rushed, and fundamentally political. An attempt to sideline Uganda's most durable opposition figure ahead of 2026 Ugandan election. The prosecution says none of that matters, that the venue and the politics of the case are irrelevant to whether the evidence supports the charges, and that the process, however slow, is functioning as it should. Both of those things can be true at once, or neither. That's the court ultimately to decide. But the pattern of what's happened procedurally since the case moved to civilian court raised real question. Since February 2026, the case has been characterized by one thing above all: delay. But what delay exactly depends on who you ask. February 24, 2026, the trial was meant to move towards scheduling. Instead, it collapsed over an incomplete disclosure of evidence. Defense lawyers Elias Lukwago urged the prosecution hadn't given his team what it needs to prepare. The judge, Emmanuel Baguma, ordered full disclosure by March 3rd. March 2026, full disclosure didn't quite happen either. Instead, the prosecution asked the court to let 6 witnesses testify under pseudonyms, Witness A through Witness F, citing safety concerns and an alleged threat against one of them. The defense pushed back hard, urging the state had actually held these witnesses' statements since March of the previous year and had simply chosen to delay disclosing them. The court ordered the prosecution to properly serve its own application because the first attempt hadn't even been correctly delivered to all the defensive lawyers. April and May 2026, cross-examination of a state attorney over that same witness protection request dragged on for weeks. June 2026, the defense tried a different legal maneuver, asking the court to refer constitutional questions like whether 7 days was adequate time to prepare for a hearing. To Uganda's Constitutional Court, the High Court dismissed that bid, ruling questions didn't arise to genuine constitutional issues and cleared the way for the trial to actually begin. Around the same time, the prosecution abruptly withdrew its own witness protection application, saying it no longer wanted the sideshow to keep delaying the main event. In June 2026, this is where the story escalates sharply. Besigye's lead international counsel, Kenyan senior lawyer Martha Karua, was reportedly declared persona non grata by Uganda's authority, barred from the country. Another of his lawyer, Elias Lukwago, the former Lord Mayor of Kampala, was arrested at his own home and charged with misprision of treason, the same offense his client is accused of. Besigye and Lutale, writing from Ruzira prison, accused the trial judge of trying to rush bail hearing while they had no functioning legal team. They said that made concepts like adequate time and legal representation of choice meaningless in practice. Their bail application was denied. Museveni, for his part, he went on a national television and accused Besigye of exactly the opposite, of deliberately delaying his own trial through what Uganda called courtroom tactics, and challenged him to use the trial to clear his name instead. So, depending entirely on who is telling the story.
They have been talking about Dr. Besigye and Abedi Lutale, who were found at Riverside. They never mentioned this third party, this soldier here whom they have brought here. So of course they are up to a mischief.
That there is nothing in the Constitution that confers upon the UPDF civil or criminal.
This is either a government methodically dismantling a political opponent's defense, or an opposition figure and his legal team using every available procedural tool to avoid a trial they know they will lose. Here is the wider context you need. Uganda heads into a national election in early 2026. An election in which Yoweri Museveni, since 1986 and now approaching 80, is again seeking re-election. He would be one of the longest continuously serving heads of state in the world. Besigye has long been considered one of the only opposition figure with a national name recognition to seriously challenge that dominance alongside a newer figure like Bobi Wine. A treason charge with a possible death sentence functionally removes him from the political stage regardless of the eventual verdict, because it keeps him detained through the election cycle itself. That's precisely the argument human rights group and international observers have raised, that regardless of the individual merits of the case, the timing and process look less like an ordinary law enforcement and less like coincidence and more like a tool of political management. The Ugandan government's position is consistent and simple. This is not persecution, this is prosecution. Officials maintain that no one is targeted for their politics, only for actual crimes, and that due process, however slow, is exactly what's playing out on camera every time Besigye appears on that door. Both narratives can't be fully true, but you watching this are in roughly the same position as any outside observer, watching a trial where the process itself as contested as the underlying accusation. As of this recording, Dr. Besigye remains in Ruzira prison. His trial has not meaningfully begun on its merit. Over a year and a half after his arrest, his lead lawyer has reportedly been barred from the country. Another lawyer faces the same charges as his client, and Uganda's longtime president has publicly weighed in on live television. Whatever you conclude about guilt or innocence, one thing is hard to dispute. This case has become less about a single set of charges and more about what kind of country Uganda intends to be as it heads into another election under the same president who has led it nearly 40 years. This is the fast moving story, and by the time you are watching this, some of these developments may have already changed. I'll keep tracking it. Kindly subscribe, like, and share.